Hi, my name is Paul Taylor. I'm an injured worker and I've been an injured worker for over 25 years now. I'm also a student presently in labor studies at McMaster University. I'm also a licensed paralegal by the Law Society of Ontario. Finally, I'm an advocate for injured workers. This means that I fight for the issues that involving injured workers. I use the courts as best as I can, as well as attend rallies for injured workers. This is all to raise awareness of the plight of injured workers and how they've been unjustly treated by Canada's workers' compensation system. I want to first talk about my work injury and my workplace and what led me to all this. My workplace involved an employer that was a temporary agency. This meant basically that the main employer or employer client or whatever you want to call it, but in my mind, the employer, got out of any responsibility for labor issues or obligations, specifically and most importantly, workplace safety. If their workplace was extremely dangerous, rarely if ever, an investigation would be done or was done, because workers feared being as they say, they no longer require you. In common terms, terminated. This was often stated to me and other workers, so I can attest to that fact. More importantly, it allowed the employer not to claim any workplace injury claims. In Ontario, the Workplace Safety and Insurance Board, which changed its name in January of 1998, and I'm going to talk more about this change, the WSIB, only recognizes employers that you work directly for. They'll often say that when a worker is injured, they investigate and the employer is held accountable. But this isn't true. In fact, this could be nothing further from the truth. What I want to talk about now is my personal fight. I had been fighting within the workers' compensation system, as I said, for over 25 years. I'm still fighting this very day. In about February of 2014, I filed a civil lawsuit against the Workplace Safety and Insurance Board and the Workplace Safety Insurance Appeals Tribunal. Now let me be clear about something. I wasn't suing just for benefits as a whiny crybaby injured worker. This is what the boards and tribunals legal counsel always portray. Oh, they just want to get out of going through the appeal process. Ironically, I had gone through the entire appeal process. I had even done what's called as a request for reconsideration, which was, they'll say denied, but I say ignored. I then decided to make a civil suit. It wasn't because I didn't agree with their decision. It's that I learned of their conduct, which was, how would we say, is horrific. The legal term is bad faith. Bad faith is defined under the law as an intentionally deceptive knowing act. The board and the tribunal had done this many times to me in the past. For example, the WSIB had repeatedly forced me back to work. In 3 separate occasions, I found a documented proof that the employer had intentionally suppressed those repeated new injuries and accidents, and the board did nothing. They still do nothing. That to me is bad faith, warranting of a civil suit. Now, again, let me remind you something about suing a board or tribunal. Within the law, it clearly states the staff have limited immunity. In my mind, when we talk about immunity, the only one that has any immunity would be the Queen or God. The Queen, who cares? Honestly, people raise issue about the Queen all the time. But let's be honest, she has no interest in me as an injured worker or you. Who cares in that sense? She's a figurehead in Canada. That's it. Anybody else, as we've learned in society, are accountable under the law for their intentional wrong actions. Let's even look at judges, for example. Judges who are appointed to their position for life. They too can be held accountable. An example was a Quebec judge, a judge at the Quebec Court of Appeal, was found and convicted of murdering his wife. He is presently sitting in jail for that. So yes, everybody is held accountable. The question is, what is the threshold or what is the requirement? And with employees of the workers' compensation system, the general threshold is one must prove bad faith, intentionally knowing deceptive conduct. That was my argument that I made, but here's a more important point. I was never suing the staff of the board or the tribunal. Never. I felt it pointless, and this is why. An employer is responsible for the hiring of staff, for the training of staff, and when necessary, the discipline, and even more so, the firing of staff. They're solely responsible for the staff's conduct, whether their staff are acting emotionally, irrationally, or illogically. The employer is responsible. That's why I never sued the staff. I sued the employer, the WSIB and the WCB. The reason why I bring this point up now about my civil suit was that the board and the tribunal in my civil action said that the board and tribunal were immune, that they couldn't be sued. They lacked the legal capacity to be sued. But within the law itself, it never gives any immunity to the board or tribunal. What it says is the staff have immunity so long as their conduct is in good faith, meaning when they act in bad faith, they can be sued. It further goes down in the law in further sections and says it does not relieve the board or the tribunal of their legal obligations, meaning they can be sued. But the strange thing in this civil story, in my story of my civil suit, is that somehow the board and the tribunal evaded responsibility of any kind as a typical employer. That's just one story. Another one in the courts of my personal fight was when I filed an application. It's called an application for judicial review with the courts. And what it is within our Constitution in Canada and in many countries is that our government structure or regime is broken down into three parts. The legislature, who enacts laws, the executive, which in the case of Canada would be the Prime Minister and the Cabinet, who carry out those laws. But the important part of a constitution in a country, not the Constitution, but the important part is the third part, the judiciary. This is why judges are appointed for life or until the age of 75 and can't be fired or terminated. You want somebody to say the decision of the court, or the decision of the government is wrong, and I'm not going to be influenced about being fired because I'm guaranteed that right. And that is really important in a fair and just and democratic system. This is why I'm puzzled by the civil system. This is why I'm puzzled by the court's decisions that I've experienced. In specifically is that when a government body, whether it be the Prime Minister, the Premier, a government agency, or a government officer meaning a member of the government office like a board member or tribunal panel member, act inappropriately or render a decision that's wrong, or when that board or tribunal or any government office issues a policy that conflicts with law and or a constitution or charter, then one can bring a claim to the court. This is usually called an application for judicial review. Judicial review is a constitutionally empowered thing of the court of oversight of government. This allows people to protect their rights. There's, believe it or not, there's actually several types of judicial review. The most common is Satori. I always screw this up, but it's basically in simple fact is when one says the decision of the tribunal is wrong and the court says yes it is and sends it back either to the tribunal or reverses the decision. There's another common one too. It's called a writ of mandamus. And this is when one, like myself, will go to the court and say the board or tribunal isn't doing their job. And I'm asking you to compel them through an order of the court to do their job. A very famous case that a mandamus application within the workers' compensation system was in Alberta. I read it. And I'll tell you, I've never been so empowered in reading the judge's comment. What had happened was an injured worker had lost their case or was denied their benefits with the Alberta Workers' Compensation Board. They then appealed to what they call as the Alberta Workers' Compensation Appeals Commission. I say that because a lot of them in Canada, it's usually tribunal, but at any rate, the Appeals Commission completely reversed the decision of the Compensation Board and ordered that the worker get benefits. The board, strangely, said, no, we're not going to do it. What do you do then? What the worker did, the injured worker, is they filed an application before the court of a writ of mandamus. They asked the court to order the board to follow the decision of the Appeals Commission. And what the decision of the court really just inspired me in the sense of justice does exist was when the judge said, well, you may be able to ignore the Appeals Commission, but if you ignore my decision, I will hold you in contempt. Needless to say, they carried out his decision. It's a fascinating thing is learning about the law, but it's also extremely complex and difficult, and needless to say, very stressful. This is my 25-year fight that I'm talking about. And that's what I did. What was interesting is in mentioning applications for judicial review, when I had done my civil suit, it finally was resolved by the Supreme Court of Canada. Yes, I did the application, it was denied, or the civil suit, it was dismissed, appealed to the Court of Appeal. And even at the Court of Appeal, I found very strange was when I walked into the room of the judges, the principal judge said, that's the one in the middle who speaks on behalf of the panel, said, well, this is workers' compensation. This should be judicial review. You shouldn't be suing them. And I felt like saying, well, okay. So in other words, if a board staff member picked up a gun and held it to my head and pulled the trigger, would my family have any rights as a Canadian? Would they have any justice? But I thought, no, don't keep your comments to yourself. But in retrospect, maybe I should have. Because it seems like the board and tribunal and its staff, I don't care about the staff. The board and the tribunal itself have absolute immunity comparable to that of the Queen. To me, this is completely wrong. But getting back to the judge's comment, they said, well, do judicial review. So in April of 2020, when I finally got the decision of the Supreme Court of Canada, who was not interested, I add, in my civil claim and the points I had raised, I then filed an application for judicial review certiorari. And surprisingly, the tribunal dismissed it for delay. They said there was no reason for this delay. Wait a minute. I had filed a judicial review application. Then I filed the civil appeal. I had showed my intent. I've ticked off all the boxes for a reasonable explanation for everything in the criteria of an appeal. And I'm going to talk about this later in other videos. But the court dismissed my application. I then appealed to a panel of 3 judges, not the Court of Appeal. They dismissed it as well and said there's no reason. In fact, what was fascinating about this issue was that the lawyers for the tribunal had provided me legal advice. And the judge said, when she dismissed my application, because you didn't follow the legal advice of opposing counsel, in effect, I'm dismissing your application. Because had you, there would be no delay. And I'm like, what? So in other words, I have to follow the advice of opposing side? Doesn't that violate the rule of law and simple arguing? Like if I take a position and they take a position, are you now punishing me for taking that position? Apparently so. I then applied for what they call as leave to appeal or permission to appeal to the Court of Appeal. Ironically, that was recently dismissed. Another video and another story about that. My next move is to appeal to the Supreme Court of Canada, not on the grounds of my workers' compensation case, but on the grounds and the reasons the courts dismissed the application and the reasons that they dismissed my appeal. It is literally, in my view, what judges would call an error of law, meaning the judges ignored the law. and they cannot do that. Well, they're not allowed to do that. They can do whatever they want. Anybody can. And that's the confusion. At any rate, that was my personal fight. And over the years, I realized in talking to other injured workers that I wasn't alone. So then I started to tell my story. And one thing I learned was that in representing myself before the workers' compensation appeal system, and frustratingly and sadly before our civil court system, that there was very little information and resources to help injured workers or anyone. So then I decided to create a website called FightWCB.org to provide some resources and, more importantly, to tell my story and provide documents. Like, it was very difficult for me. What's a notice of motion? How is it used? What's a factum? I don't know what they are because I don't have access to see them. So this is why, in one main reason, I created the website to help injured workers who are representing themselves, to help them understand the workers' compensation process and better fight, hence the term Fight WCB, Fight the Workers' Compensation Board or system, right? I also, in my personal fight, I actually ran for election in provincial. And how this came about, I was originally living in Guelph, Ontario. And part of my advocacy was as I created the injured worker group in the Guelph region. And that's part of what's called as the Ontario Network of Injured Worker Groups, or ONIWIG. The group had been doing a campaign to raise awareness of injured workers. And they had asked me to speak to my local MPP, which was a Liberal, Liz Sandals at the time. I had previously talked to her about suing the board and my difficulties within the courts. So I had emailed her office and said, I'm a resident of Guelph and I'd like to talk to the MPP about this campaign that we have going on. And I was shocked and angered because the MPP's response back was, she doesn't want to talk to you because you're suing the government. I was like, what? Seriously? So, ironically at the time, the elections were just occurring. This was around May or April of 2018. This prompted me to run in the election. Well, actually, I always say walk because I don't run, right? And I did. And I actually had quite a bit of fun. My frustrating part was my first debate was up against Mike Schreiner, the leader of the Green Party. His local candidacy was Guelph, and I'm like, oh great. Running against the leader of a party, that's going to be very difficult, and it was. But you know what, I had a lot of fun, and surprisingly, my first debate, I actually made it into the media, the papers. They took note because I said, great, you sat me right beside the leader of the Green Party in an environmental debate where all your responses go from left to right, and I'm the right to him, so I have to follow all his responses. And my response to that, I said, shit, I should have sat at the other end of the table. Well, sure enough, the reporter for Guelph Today caught me saying that, and he quoted me in the article. So it was an interesting thing. I ran again in the June 2020 election, and again had a lot of fun. So I'm going to talk about my experiences in running for political office. After that, in about 2018, 2019, I realized in learning about our Constitution and Charter, because as well I'm going to school, that's why you see all these things behind me. My sister bugged me for many years, you've earned these diplomas and certificates, you need to display them. Don't ever be ashamed of them. So I did. And that's just some you can see. But at any rate, in learning about the Constitution and law, I realized that as an injured worker, I actually did have rights as a Canadian. And this applied to me as a Canadian citizen working in Canada. This also, believe it or not, applies to foreign workers that are temporary workers and work in Canada as well. And I'm going to talk in other videos about the National Charter Class Claim, which I filed and is presently underway right now. So this is the first of a series of videos, and I'm making them mainly because the one thing I realized as a person that is an injured worker with numerous disabilities, including anxiety, depression, and I also have ADD. This is why I have many projects on the go and I'm all over the place. That like-minded people like myself, which is many injured workers, struggle to read a very lengthy and complex document. Moreover, many injured workers suffer from secondary injuries from just dealing with the workers' compensation system. I've often thought about this clear example about the forced return to work. The board always says, no, it's safe and suitable work, but they never ever use those words in dealing with injured workers. Instead, they force them back to work that is unsafe and unsuitable for them. Here's a good example. Imagine you're a woman, or even a man, but let's just focus on the woman, and you work in a place and you were violently attacked and raped. According to WSIB policy and law in Ontario, they can force you back to that workplace. And the worst part is if the employer says it's safe or modified work, they always use the word modified work, and you've got to watch that. At any rate, if they say, no, the work's been modified and blah, 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 and you're this rape victim and you now have to work beside the predator, you're going to literally have, I guess you'd call it a breakdown. And the worst part is, according to the law, you get no benefits for this. That's very disturbing, and that's just one of many hundreds, thousands of examples of the problems with Canada's workers' compensation system. A system that, in its beginnings and even throughout time, worked well. And what I'll explain is how it fell apart. The beginning of it falling apart was in 1990, and more progressively in 1997 in Ontario. And it spread across the country. It seems that Ontario is the epicenter or the focal point or the starting point of all that's gone wrong with workers' compensation in Canada. After all, it was the starting point of the creation of it. But I just want to thank you for taking the time to listen to my video and any future videos I do. I hope to make a series of them, and I'll talk about my stories and my fights of workers' compensation, and hopefully it will teach you and, more importantly, inspire you to fight for yourself and your rights. Thank you very much for listening.